agree with Mr. Pasulka. We wouldn't necessarily.
You don't have to.
No, you don't have to deal with that. They came back to court and said, well, Judge, somehow we didn't get to a contribution hearing. We'd like to have one. The court might not consider it at that point.
Yes. The question is whether it affects all cases pending as of October 1. The answer is yes.
Sure.
I think this is an excellent program. I'm a non-matrimonial lawyer. I've arbitrated about 10 cases. I know where Ed's coming from in the sense that it's most way private cases. The judges can do that with experienced counsel. What I was a little bit concerned of program in the community is there's not a consistent expectation among attorneys or clients attorneys. How do we get them to embrace the program?
The question, yeah.
I'm a little concerned about that because when Judge Evans goes out, when I go back and say this is a great program, and they say, well, what's going to happen? How do you run it?
The question is how are people going to be convinced to participate in the program, I guess. I mean, a lot of it's just going to be the experience of knowing that cases went through and that people felt that it was a fair process. And some of it will just involve the judges addressing that with the parties when they offer that option up.
And in addition to that, he raises a very good point. I would like at some point to get some statistical data which we might be able to make available. The thrust in the court system, at least in Cook County, is to try to have more disputes resolved amicably. And I think every time we can get something published about how well a program is working, people then will have less reticence to embrace it. It's not automatic, I agree with you, but I think to the extent that we can get the word out, we can go out to the various groupings in the community and let them see the statistical data themselves, they might become more comfortable with it. But it starts with the lawyers who practice every day, and it starts with the litigants who are currently in our system.
Years ago, there was a mediation program that kind of wanted to see how they really.
Sure.
And there are a lot of, I'm a business person, a lot of us were signed up. But what everybody found was the litigants wanted to retire attorneys, who were offered I don't know that that's the only part of the program that will make it successful. That's why I think it's a great program. But I just, I really thought of it as sort of guidelines. Whether expectations 30 minutes, 35 minutes, or less wage, clarity.
Well, I appreciate the suggestion, and I certainly will confer with our colleagues as we go forward, and I know you'll be jotting some things down as we go through this. If we need to make adjustments to get the word out that way, I'll be happy to try to do that.
Yes. The first question was, what is the status of the mediation agreement? You mean, where are we at in terms of what those procedures will be? Oh.
Yeah, what the parties agreed to, if there's an agreement, it would then go to the judge to be submitted and become a court order. And what was a partial agreement? I usually, this is going to be over the total fee amount, but if there's sub-issues, I see that as a possibility that the parties could reach an agreement and say, look, we're unable to reach an agreement on this one issue. Could you rule on that? I see that as a possibility.
Yeah, we would welcome that. If it turns out, let's say they had a dispute involving 10 matters, and say 8 of the 10 would be resolved through mediation, and they only had 2 left, we would take that because that would be less time in court, less expensive to the litigants and so forth. So yes, we would encourage that. We hope that all of you will be successful 100%, but we'll take whatever you can do.
Well, we'll count that as 80% right there, 8 out of 10.
Yes.
Another mediator type question. How long after being successful in
probably would look very closely at an issue like that. We would not give anybody any extraordinary time. They'd probably be permitted some relatively short discovery time. But if the case came back to us and both sides said, Judge, we're ready, we have judges who are called swing judges. There are 3 of them who every day stand ready to hear a case like that. If they expect to be heard automatically by the same judge who heard the case in chief, that wouldn't necessarily be something that I'd embrace. If they're ready, we'd send them immediately to trial. We don't want to prolong this, and the last thing we want to do is have the alternative dispute resolution procedure lead to even more time wasted. You know, we'd like to see them moved immediately to trial, or as close to that as we possibly could arrange after they've gone through all that you could do.
Short time for you is 1 week, 1 day, 6 months. What's short time?
Well, for example, if somebody sent the case back, we got it back today at 5 o'clock. We'd have a judge ready tomorrow to start the trial. I think it would be unlikely that something like that would happen. They'd come back to me and they'd say, okay, Judge, here are my witnesses. I expect to have X number of witnesses. We need to get ABC, something like that. I'd say, all right, we'll extend this for the time that's needed. Let's say they're asking for 7 days. That's probably reasonable. If they're asking for another 30 days on top of the 30 days that they will have had for discovery in the interim, that probably would be denied. We would be looking to see recalcitrance, somebody trying to use the system to keep from paying, that type of thing. We'll be very closely watching that.
Okay. Well, thank you all for sticking around and for coming, and we'll see you Monday.